Chief Minister Fabian Picardo joins us now in the studio. Mr. Picardo, thanks for joining us.
Good evening.
You say this has been prompted by the Supreme Court decision, which focuses on abortion in the case of fatal abnormality in the fetus and rape and incest. Can this be seen as an indication that the government is looking to legalise in these cases?
Well, I think that you don't need the government of Gibraltar to legalise in those cases. The important thing for people to understand is that the United Kingdom Supreme Court is actually exactly the same court, just with a different name, as our ultimate court of appeal, which is the Privy Council. So this is in effect a decision which will be very persuasive, almost binding, if anybody goes on appeal from Gibraltar to the Privy Council. And therefore, we need to understand that this is a modification that is more or less now set in a jurisprudential stone for Gibraltar. And therefore, we need to look at how our statutes change to ensure that they are now compliant with Article 8 of the European Convention of Human Rights, which is in almost identical terms to Section 7 of the Gibraltar Constitution.
OK, so in this case, does this mean that this is the extent of any potential revision? Are we considering any other options for legalisation of abortion in other cases, or is that off the table at the moment?
It may be. This is why the consultation process needs to involve not just those that are pro-life, also those that are pro-choice. And the work I've done already, which has been to meet those groups at their instigation, has really opened up the possibility that there might be consensus between them. For example, I think most people who have come to see me or expressed an opinion to me, who are in the pro-choice camp, take the view that 24 weeks would be too long a period for the possibility of abortion. And those who represent the pro-life camp have also suggested to me that they do not see the possibility of anything happening after, for example, week 12 as something that they would be able to rationalise in the context of the decision that there has been. So I think if we sit together and we look at this carefully in a considered way, I don't know whether we will be able to actually achieve consensus, but from what I've heard of the groups that have come to see me, there is a lot more consensus than you would anticipate when you represent one side as pro-life and the other side as pro-choice. A lot of what they said actually demonstrated that there are some failings in the way that government and health authority provide support for women who find themselves in a situation of unwanted pregnancy, and that is as much about health provision as it is about social provision, and decisions being made by people to abort which are based not on any desire to make that decision, but finding themselves unable to make any other choice. And we need to address those things as much as we address the letter of the legislation. This has been a real eye-opener for me, not just in terms of what prompts the move, which is the decision of the Supreme Court, but the sensitive and careful way in which people who have come to see me from both sides have represented their views, and the very touching testimony that we've read of some women who have aborted, who live in Gibraltar, and who look at the law as something that criminalises the actions that they've taken and they've taken abroad.
So it was interesting to see that there's some common ground between groups who have such opposing, contrasting points of view. So tell me, the government has previously said it does not have a mandate to revise Gibraltar's abortion law. Why does it feel it has one now without, for example, a referendum?
Well, because this is not any longer an issue of mandate. We're not a party that's going to, or a government that's going to flip-flop on these issues. We're very clear that we don't have a mandate to originate a move in respect of this particular area of policy. But there is now a requirement that we move because of the decision of the Supreme Court in the United Kingdom, and that really changes everything. Once that has happened, and because we now take the view that it's very likely that we have to change our law, and there is a debate around how that law should be changed, it would be irresponsible for us not to talk to all of the groups in our society that have expressed views on this, to try and reach that consensus, and to then publish something. Remember, the government here is not going to publish a command paper without consultation to then consult on the command paper. What I've said is we're going to take this as a two-stage process. In fact, there will be other stages afterwards. We're going to consult first and then publish a command paper. The command paper itself will invite views from the whole community more generally. And after that command paper, we will then publish a bill for debate in Parliament as an act.
OK. And just a final question. You've said the consultation process will include pro-life and pro-choice groups. Will there be a wider consultation with the community, such as there was ahead of the legalisation of gay marriage?
of equal marriage, yes. I mean, in the sense that what we will do is that we will not just, even before the consultation paper, just talk to the defined pro-life and defined pro-choice groups as they are today. We will seek to talk more widely in the community. Indeed, we will continue to talk to our own political parties about these issues. I mean, Joseph with the Liberal Party executive, myself with the GSLP executive, and the activist base as well, because there are opinions that we must take on board there. We will talk also to other representative organisations which may not have expressed a view one way or another yet, and that will form part of our thinking as we move into the consultation paper process.
Okay, well, thanks for joining us and discussing what's a very difficult issue.